Hello, guys. We have some breaking news. Literally moments ago, Judge Liman issued an order on the Stephanie Jones motion to compel Katie Case's messages, documents, etc., which we had the hearing for on Monday, and he has denied it. So I'm just going to read through the order. Stephanie Jones and Jones Works moved to compel non-party Catherine Case to produce materials in response to a subpoena dated 17th of October 2025. Although Case initially objected to the subpoena, she expressed a willingness to confer with counsel for the Jones parties regarding a supplemental production, and counsel for both parties subsequently agreed to the scope of such a production. The Wayfarer parties now seek to intervene and object to the production, arguing that the subpoena is untimely and that any request for an extension of the discovery deadlines should be denied. The court heard argument on the motion on November 24th. The Jones party's motion to compel is denied. The subpoena seeks documents and communications regarding certain negative websites and social media posts. It was issued on October 17th, almost 2 months after document discovery for non-parties closed on August 15th. The Jones parties assert that they issued the subpoena in response to information obtained during the depositions of Case on September 5th, Melissa Nathan on September 30th, and Jed Wallace on October 10th. They contend that these depositions revealed that their prior subpoena to Case was inadequate to capture all relevant materials in Case's possession that bore on the disputed subjects of Case's, Nathan's, and Wallace's testimony. In particular, the Jones parties did not know that Case had written copy for the Stephanie Jones Leaks website and associated Twitter posts, or for several other similar smear websites at Nathan's and Wallace's direction, nor that Nathan and Wallace would deny involvement in all such disparaging websites. Counsel for the Jones parties accordingly wrote to Case's counsel on October 15th, requesting that they accept service of a supplemental subpoena and that the Jones parties served that subpoena 2 days later. Case and the Jones parties subsequently agreed to the scope of a supplemental production, but on November 11th, the same day production was set to begin, the Wayfarer parties noted their objection to the subpoena, citing proprietary and potentially other interests of our clients, Tag and Nathan, in the documents. This motion to compel followed. As an initial matter, the Jones parties argue that Tag and Nathan lack standing to object to the subpoena because a party has no standing to seek to quash a subpoena issued to someone who is not a party to the action unless the objecting party claims some personal right or privilege with regards to the documents sought. The court agrees that the Wayfarer party's conclusory assertions regarding proprietary and potentially other interests in the documents failed to establish some personal right or privilege with regards to the documents sought. That is especially true given that Nathan and Tag have expressly denied that any work Case did on the websites or social media posts was on their behalf, going so far as to suggest that Case's testimony to the contrary was perjurious. Nevertheless, courts have indicated that the issue of standing is separate and distinct from the timeliness issue, and that the fact that the timing of the service of the subpoena violates the scheduling deadline set by the court forms an independent basis to grant this request to quash. A scheduling order is an order, just like any other order of the court, and may not be ignored or disobeyed simply because the parties agree to do so or because one party lacks an interest in the documents sought. And he quotes his Fairy Puppet Studio. If the Wayfarer parties had issued a slew of pre-trial Rule 45 subpoenas for documents and testimony well after the court-ordered deadline for discovery, the Jones parties would not have been powerless to present that violation to the court. And that is what he said in that hearing. And that's exactly what made me think, he's not going to grant this. The same principle applies when it is the Jones parties and not the Wayfarer parties who are seeking to enforce a subpoena issued after the period allowed for the issuance of such subpoenas. Footnote here. The Jones parties assert that the Wayfarer party's objection to the subpoena is itself untimely, but given that the issues raised by the Wayfarer parties implicate the use of judicial processes, i.e. issuance of court-ordered subpoenas, and the court's own discovery deadlines, the court has an interest in reaching the issues just as it does even when the objecting party lacks standing. So he's saying, well, you abused the court processes, so now the court has got a standing in this. Okay. A party must show good cause for the issuance of such a subpoena and thus for a motion to compel compliance with that subpoena. The Jones parties have not established good cause. They argue that their decision to wait until October 17th to issue the subpoena should be excused because the full scope of relevant communications became known only on October 10th, after the completion of Case, Nathan and Wallace's depositions. However, Case was deposed on September 5th, and the Jones parties would have been aware, at least at some point, that there likely existed relevant documents that had not been produced. Case testified that she wrote copy for the Stephanie Jones Leaks website and other similar smear websites at Nathan and Wallace's direction. At that point, at the latest, the Jones parties could have issued the subpoena. The Jones parties argue that Nathan and Wallace had not yet testified by September 5th, but that does not excuse the Jones parties' failure to timely issue a subpoena once they became aware of the existence of the documents. Nathan and Wallace denied any involvement in the creation of the websites. Thus, there is nothing that the Jones parties would have learned from their depositions about the likely existence of documents that they did not already know from Case. Even if there might have been a cause for the Jones parties to wait until after Case's deposition to serve the subpoena, the decision to wait an additional 6 weeks before doing so demonstrates a lack of diligence. Oh dear. The Jones parties' additional arguments fail to overcome this flaw in their good cause showing. They argue that the Wayfarer parties will not be prejudiced by an amendment to the scheduling order because the court has not yet set a deadline for summary judgment motions or trial. Remember, this is the Jones docket. That's why there are no deadlines yet for trial or summary judgment, in case anyone gets confused and think, well, hold on, we just had summary judgment. This is on the Jones docket. Summary judgment and the trial dates all set for the Lively docket. But that does not mean that the parties are free to continue to issue pre-trial fax subpoenas up until the moment of summary judgment. The absence of prejudice alone is insufficient to show the presence of good cause. Scheduling orders exist to protect systemic interests in the just, speedy, and inexpensive determination of every action and proceeding. The court itself has an independent interest in compliance with its orders. It thus is not enough that the adverse party is unable to show prejudice. The Jones parties also contend that the Wayfarer parties' delayed and deficient disclosures throughout the course of discovery provide a basis for finding good cause, especially given that the Jones parties have also raised concerns regarding alleged spoliation committed by the Wayfarer parties. That argument also does not answer the concerns of the Wayfarer parties and of the court. If the Wayfarer parties failed to produce documents they should have produced, then the Jones parties should have filed a motion to compel against them. And if, in fact, the wayfarer parties have spoliated evidence, the remedy is spoliation sanctions. The Jones parties have failed to show that any discovery violations by the wayfarer parties provide good cause for their failure to serve the subpoena earlier. Next, the Jones parties argue that they do not need to demonstrate good cause because case consents to the current production. It is true that parties and non-parties need not seek the extension of court-ordered discovery deadlines to exchange documents or to engage in informal discovery. A party may ask a witness for information and documents after the close of discovery, but that is not what the Jones parties are seeking here. The Jones parties issued a formal subpoena for the documents, and Case agreed to produce the materials so as not to violate any directive of this court. The Jones parties are now moving to compel the production of the documents. Thus, although there is nothing that would prohibit the Jones parties from asking Case to voluntarily share the documents at issue, what the Jones parties cannot do is issue an untimely subpoena without court permission and then ask the court to enforce that subpoena without a demonstration of good cause. Finally, the Jones parties argue that the documents bear directly on Nathan and Wallace's credibility. Case says she prepared the website and social media materials at Nathan and Wallace's direction, while they assert the exact opposite. A party may, under certain circumstances, issue a trial subpoena after the close of discovery when it intends to use the documents it has requested for cross-examination and impeachment only. The Jones parties have not framed the subpoena as a trial subpoena, nor have they indicated that it is for cross-examination and impeachment purposes only. The court therefore does not address that issue. The motion to compel is denied, so ordered. So there we go. Jones is not getting her subpoena compelled. I wonder what delights will come later. That was a nice surprise. All right, guys. I will catch up with you in the next one.